The law matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program has been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We provide information and resources that'll help you decide whether or not you might actually be able to handle some issues yourself. If you do decide that you need to contact a lawyer, you'll be better prepared, and hopefully so will they. The goal, of course, is for you to achieve better results, save time, and save money. We welcome and thank the Bazar Grasso law firm in East Providence for providing us information and insights in each one of our sessions. Attorneys Jacqueline Grasso and David Bazar comprise the team, and with us today, of course, is David Bazar.
Hi, Debbie.
So today our discussion will be about arbitration. And there's a recent spate of controversy about banning class action suits. So companies insert individual arbitration clauses that severely limit your ability to make resolution. And those are particularly about the fine print that you almost never read. And even if you do, what can you do if you think something is unfair? You don't buy, you can't buy, or you do buy, and then you suffer the consequences perhaps if something doesn't quite work out. What do you do about that dispute? Recently, there was a front-page New York Times story, and it cited that the American Express company, in page 5, in a small print, they put in the text something to the effect, 9 words that made such a significant difference. They may elect to resolve any claim by individual arbitration. So in other words, you couldn't form a group. So there's apparently a very strong trend in America today that says, as a result of these kinds of suits, that Americans are actually locked out of court. So we don't want to encourage lawsuits, but if you're being deprived of your right to sue while joining others, you may be considering yourself at a distinct disadvantage against that 500-pound gorilla. So it might be your cell carrier, it might be online, it might be credit card companies, it might be a lending company. And if they are subjecting you to unfair practices, such as the predatory lending, what can you actually do? So if you are joining a group these days, that group that might want to sue may never see the light of day. So today we're going to explore arbitration, its intended benefits, and some of the things that have been derailed. So David, give us a 411. What is arbitration?
Well, we've talked about arbitration before. Arbitration is a form of alternative dispute resolution where instead of going to court, you have a case that's heard in front of an arbitrator who listens to both sides and then decides how the case should be decided. The issues are what type of arbitration is it, because there can be many different types of arbitration. In baseball, they have baseball arbitration. In that type of arbitration, a player submits his demand for a salary, the team submits its offer for a salary, and then the arbitrator listens to both sides and has to pick one or the other. So you hope that by doing that type of arbitration that both sides would be somewhat reasonable in submitting their proposals for the arbitrator, but oftentimes the player's high, the team is low, and they end up settling anyway. Most forms of arbitration through court system don't involve baseball arbitration or that type of style. There can be binding arbitration, which is you have the case heard by an arbitrator, and whatever decision the arbitrator makes is binding, or non-binding arbitration, which still allows the parties to pursue their case in court.
So when they're talking about arbitration in general, it's been mostly employment contracts and things of that nature, but certainly now we're hearing about credit card companies, cell phone companies, even online. I think you've spoken before about making sure you read all that fine print, which most people don't, but by the time they find out that they have something that is needing to be challenged, when they're told that they can sue on their own. But of course, you against American Express, you against Chase Manhattan Bank, often you're feeling like things aren't fair, and what am I supposed to do as one individual? Do you find that there is generally fairness in most of the smaller kinds of cases that you might deal with in arbitration?
So you're raising 2 issues.
Several more, too.
And several more. So the first issue about these terms that are in contracts. The worst of those are those terms that force you as an individual, in some instances, to have whatever resolution you want to a case, whether through suit or arbitration, to go to some faraway location where the company, this massive company, may be located, or they prefer the law of that state. So the terms might say, if you have a dispute with us for something involving this contract that you've entered into in buying some pencil online, you have to come to Texas and sue us or have an arbitration in Texas. And of course, the issue is, if it's even a $1,000 TV that you bought, who's going to hire a lawyer, fly to Texas to arbitrate a claim against a company on their home turf with laws that probably aren't favorable to the consumer? So you have that issue. And then you have the issue of whether or not you can even sue. And then the third issue that you raised is whether or not you could sue as a class action. So we should talk a little bit about the purpose of class action suits.
We could start with that, but I also wanted to ask you, when it comes to something like arbitration, there's supposed to be distinct benefits from that, and from what I've been trying to read, it seems that that has become a more popular thing for companies to do. It's supposed to be less expensive for them. They don't have to have lawyers. You don't have to have a lawyer. Perhaps we can just deal with it one-on-one or with mediation or whatever. So is it supposed to be, is that one of its benefits, to be less expensive if you can work it out? More flexible if you can work it out? You just cited an example where it might be neither.
That's the theoretical benefit of arbitration. And when used correctly, and in certain instances, it absolutely does all those things. It saves time, it saves money, it saves attorney's fees, it saves stress. Lawsuits are stressful. So arbitration used to resolve a lawsuit can have a multitude of benefits. The problem is when you're forced into arbitration, and as we said, in a location that's not convenient, when your rights are limited to just arbitration, it really puts you as a consumer, because usually these are consumer situations where you're dealing with a larger company, at a big disadvantage. So arbitration used correctly has all of the benefits that you cited. But arbitration, when it's forced on you and limited as to what you can do and where you can do it and how you can do it, can take away a lot of rights.
So, as you were just about to discuss, class action suits. Explain that a little bit, and we'll talk about some of the problems that are caused by it.
So, the usual reason that a class action suit may take place is we're talking about small claims by a lot of people against a company for unfair practices or defective product or something, where the injury to the individual isn't that great. But to get recourse individually, it might not be possible, because you're not going to find a lawyer to sue a major company for a defect part, say, to a TV that would cost you $300, $400, $500 to fix, and the expense of a lawsuit or even arbitration far outweighs that. So what happens is, when the company is knowingly, say, perhaps producing a defective product and doesn't fix it, if you can band together with 1 million people who have that same problem, so then you have a representative plaintiff suing on behalf of all likely situated people, in other words, people situated in the same circumstances as you, then that is a much more economical way on behalf of the plaintiff to join in and have a recovery for something they're entitled to, as opposed to being forced to individual arbitration or litigation.
So those big companies, even before there's such a thing as a class action suit, they say, well, let's just deal with individual arbitration. We'll deal with it one-on-one on the phone or email or however that goes, and it'll make life easy for everyone, if only that were true. But obviously it's not been true, because there's been not just a spate, but there's been such a surge in the number of suits that are wanting to be class action, because so many are having problems, as you say, whether it's a defective product or just business practices that were unfair. And the New York Times had cited so many different kinds of cases. So it made sense that many companies will want to not allow a class action suit to happen, because I guess there really is strength in numbers and bad publicity to boot.
Well, not only is there strength in numbers and bad publicity to boot, but there's also a risk for the company to have to pay a large award or settlement because they've created a lot of damage for a lot of people. Whereas individually, they may not end up paying anything because a lot of people are just going to abandon a suit for $300 or $400 or $500 as opposed to just having to agree to be part of a class where it's pursued. Now, the complaint that businesses and companies have against class action suits is the lawyers make a lot of money. Well, they're expensive suits to run, and they're risky sometimes. So there is a benefit to the lawyers taking on a big class where the numbers are much larger and the return, therefore, is that much greater. But they are taking a risk because there's no guarantee in any lawsuit that you're going to win. The other thing is that by requiring people to sue individually, you're really limiting their rights. And so you would hope that most of these things that usually probably come as a result of that click on the internet or a contract that you have no control over, that a court would look at each case and decide this might be called a contract of adhesion, which means that these terms are being pushed on the consumer. The consumer has no choice, no ability to negotiate the terms. So we talked about whether you should click on I agree to these terms. If you don't agree, you're not going to get the product. So who's not going to click on it if it's the only way or the easiest way or the best way for them to get a particular product? So people click on those things whether they've read them or not, whether they agree with them or not, and if there are terms in there that are patently unfair and take away rights, I think courts should look at those very closely in deciding whether or not they're enforceable.
That certainly makes sense. A couple of points about arbitration. It was kind of enlightening to find out that when there is arbitration, it's not necessarily that lawyers are doing it. It could be someone who has a strong amount of business acumen in a given industry or whatever. And is that true?
Yes.
It is.
And there are a lot of different areas where there can be arbitration. There can be arbitration in employment situations with unions. And many times a union employee, a union advocate who's not a lawyer, will advocate for the employee on their behalf at the arbitration. And there's been some case law that says that's okay because they're not really acting as a lawyer and they're acting in an area where traditionally non-lawyers have participated in arbitration.
And what about the issue that some consumers who did try to go it alone, so to speak, and not get involved with class action suits, what if that person who is making that decision, that arbitrator, is just not fair? So you brought up this story about the baseball. Suppose the arbitrator is one who is a Boston Red Sox fan. You might say, well, how could I get a fair shake? I want to be, I'm vying for the other team.
Right.
So that's a little more blatant, or maybe not so, but how do you know that someone's going to be unbiased, which is, I suppose, the very definition of what that decision is supposed to be? How do you deal with that?
So there's a lot of different ways you can pick an arbitrator. The baseball situation is really governed by a contract, a union contract between the Players Association and the Major League Baseball. So those arbitrators are sort of pre-selected through that process.
Not a good example then, okay.
No, and there's a number of other ways where arbitrators are selected, and most arbitrators are fair and unbiased. And it's really hard to overturn an arbitrator's opinion, but I think we've seen it happen, actually, pretty recently.
Yes.
And so we talked about this before, but the NFL decided that Goodell was going to be the arbitrator for a case involving Tom Brady. And the rights of the NFL to pick him as the arbitrator were secured in the agreement between the NFL Players Association, the union, and the NFL. And so the NFL felt that, well, since we have the right to have Goodell be the arbitrator, any decision he makes is going to be upheld. But it really talks to what you're speaking of, is what if the arbitrator is biased or not fair? And in that case, the court decided, the district court for New York, the judge decided he wasn't unbiased, he wasn't fair, and here's a whole bunch of reasons why, and his decision was overturned. But that's very rarely the case because, first of all, most arbitrations involve an unbiased arbitrator, and all you have to do for your decision to be upheld is not be biased and be fair and follow the evidence. And even if you don't follow the evidence, if you're not unbiased and if you're not biased and you're not unfair, then your decision's going to be upheld. And most decisions aren't even appealed anyway.
So let's talk about your points regarding the case, so to speak. I understand when it comes to arbitration, it's unlike being in a court system, you don't have to have the same testimony, the same process that you'd go through in a court system. So theoretically, what you do as a lawyer, then you are dealing with the letter of the law. And in arbitration, there isn't such a thing as letter of the law. They may have the letter of ethics and ethical conduct, but it seems to me that there's a wide area for a corporation to be able to present a much heavier, better, airtight case than the average person who's trying to get his $600 back for the TV.
Right.
True?
True. Here's the thing. The arbitrator has to apply the law. He's supposed to apply the law. And the difference really is oftentimes the rules of evidence are relaxed. You're not held to the same standard of what you can introduce, what documents you can show. So the company that's probably been through these arbitrations time and time and time again have it all prepackaged and ready to go, where you as the individual are struggling for the first time to figure out what you can put in for evidence, how you can put it in, and what you need to do.
So how can we make this fair? When I was reading the various kinds of suits, they ranged from the Time Warner customers who had a mysterious set of new charges on their bill, not one, but so many that it became class action suit denied. A travel booking website was accused of fixing hotel prices. One guy can't do anything. Many, and then it's denied. Employment side, Goldman Sachs executive sued on behalf of bankers claiming sex discrimination in the workplace. Then there's a place like Taco Bell that had said that the African Americans, those employees were being denied promotions and given the worst shifts. One guy going to his boss, can't do anything, trying to sue, he's going nowhere. But each of these that were bona fide because there were so many, and there were so many of them that it becomes raised to class action level, they get booted out and never going to see the light of day. Can the consumer at that individual level ever get a fair shake? And if so, how?
Those are all great examples of cases that would be perfect for class action suits. The extra charges on a bill that's being charged to millions of customers that might amount to $30 on one person's bill, but $30 million across the board, is exactly what class actions are designed to protect against. And to not allow that is to say Time Warner is probably going to get a $30 million, just in my example, windfall that they don't deserve at the expense of all of these people who are being treated unfairly. And then you could argue, what's the recourse? Switch to Cox. But in some places, you don't have that option. You have what you have. And that's the problem with limited competition. It's the problem with judges who don't recognize when things such as this should be allowed to proceed as a class action suit. And you can say, well, you know, there's this contract or this rule or that type of thing, but you have to look at the bigger picture as a judge and say, what is going to create fundamental fairness sometimes? And I know as judges we're supposed to apply the law and not look at it that way, but there's oftentimes a way to apply the law that you can say, my interpretation of this statute is, if it's blocking a class action suit in an area where you don't think it should, this doesn't apply. Or if the contract that prohibits it is a contract of adhesion, you can go through the law of contracts and say, this isn't enforceable. And so, not knowing the facts of each of those individual things, I can't tell you whether it was right or wrong, but I can tell you that those are exactly the types of things that class action suits are primarily designed to protect against.
So it wouldn't be a stretch to say that you don't think that there should be a reason that the class action suit should be banned ever? well, maybe not ever, but
Right.
apparently New York State and several others, they're trying to take it out of the hands of just the judiciary, but as arbitration is supposed to anyway, I guess, but trying to legislate it so that these companies, wherever they are incorporated, don't have the right to deny class or ban. They can't ban class action suits. It seems to me that with these 5, 6, 7 that went on, it might have been $600 times so many. And apparently, whenever although there's not a government agency, I guess, yet tracking those class action suits, every time they come in front of a judge, it seems that says 4 out of 5 cases, the judges are ruling in favor of the companies. Does it need to be a legal thing to correct this, David?
Well, that's what I was saying. I don't think it needs to be a legal thing. I think it needs to be judges applying the law correctly. Now,
but if they're not?
If the law is written in such a way that is prohibiting these otherwise legitimate suits from proceeding, then the law does need to be changed. And if people are thinking of introducing legislation that prohibits class action lawsuits or these types of things, they really should think long and hard about whose rights they're protecting, because they should be protecting the rights of the people. And I do agree that there are class action suits that should never be filed, that there's no legitimate claim, there are problems with it, there's lawyers drumming up business where there is none, and the judges should be able to recognize that and protect the other side of the coin, the companies, from frivolous suits. And there are ways of doing that. But to ban things from the get-go without letting each person have their potential day in court is wrong.
Apparently there are so many of these where the judges are saying, we're upholding the ban, you're not going to be seen. It's raised enough concern that they're saying it's so unfair. Companies are essentially getting, quote unquote, a get-out-of-jail-free card.
Right.
That was never intended,
right.
I'm sure. When it comes to this being on a state-by-state basis, do you think that if there are more individuals in one state that have a similar complaint, even if it's not quite class action, but there are smaller groups cobbled together that say, we all had that same mysterious charge on the bill of our cable or whatever, can that become a joint suit without it being class action? Can groups of people get together and not have it be a class action suit and still have it work?
There are opportunities for group lawsuits for certain situations. In Rhode Island, if you think back to the station fire, that was not a class action lawsuit, but rather a joint or group lawsuit where everyone who is similarly situated, and given the circumstances and the ability to recover funds and the limited amount of money that might be available to the victims, it was treated as a joint lawsuit, joint litigation. So if there's a mass personal injury situation, it's not a class action lawsuit, but rather a joint litigation type of lawsuit where people are joined together in the same suit, but it's different from a class action suit.
So it's a good answer. You mentioned earlier binding and non-binding arbitration. Apparently in some of these cases, while they weren't talking about binding or non-binding, they were clearly saying no chance to appeal. I'm thinking that that certainly keeps court legal fees down, but it certainly does say that it's further denied people justice at a given point.
It's binding arbitration when you can't appeal, for sure.
Yes.
Because how can you change the decision if you can't appeal? But
even if somebody was unfair or whatever.
But that's what I wanted to say is, even if it says that it's no right of appeal, again, that's potentially a contract of adhesion. It's something that's being forced by one side on the other, and I would challenge it.
You would?
Mm-hmm.
At the same time, if someone comes to you and says, David, I'm one of the victims of that AT&T overcharging me $600, and this was a case, this woman decided that she wanted to sue. It went nowhere. She ended up hearing that there were several other AT&T similar cases with unfair charges levied. If someone comes to you for the $600 case, are you likely to take it, or are you likely to say, listen, it's not even worth the price of going through the details here?
Yeah, I would advise usually in that case to file a small claims action or something of that nature, because And that's the whole purpose of class action suits when you have these small claims. As an individual attorney who doesn't do class action lawsuits, to take on one person's case for $600 doesn't make sense for the client and doesn't make sense for me. So the advice would be bring it to small claims or find a class action suit for people who are similarly situated and see if you can pursue it that way.
Two more questions. One, consumerprotectioncouncil.org, are they likely, as the nonprofit, are they likely to be able to intervene on an individual's behalf when these kinds of things going on are just not worthwhile?
Yeah, I don't know what they do.
Okay.
So I can't tell you, yep, they're going to do that, or nope, they're not going to do that. I would imagine this, and I'll go back to that other thing. If you think that there's something going on in a situation where a company, whatever company, is doing something to overcharge, and they're doing it not just to you but to other people, the place to start may be the Attorney General's office.
Good.
And there's a civil section in the Attorney General's office that you would contact and run the information by the Attorney General who's in charge of that and see if they've heard of this and if there's something that they can do.
Good suggestion. One other thing, another part of your experience, although we're not really addressing it today, we're talking to you as a lawyer, but you are also a mediator. I've read that in some cases, lawyers who've been involved in these kinds of unfair practice, whatever kinds of cases, that they find that there's greater success if there is mediation and or arbitration, or mediation first. Can you address that a little bit?
So I can. I'm an arbitrator as well, and I've arbitrated many cases. I've mediated many cases. The difference between mediation and arbitration is, as a mediator, I'm not taking sides. I'm not deciding a case. I'm not telling you who won or who lost, but rather I'm trying to bring the two sides together to come to a resolution. Many mediators at the start of mediation would say, if both sides walk out unhappy, then I've done my job, as long as the case is settled. So what we try to do is bring the plaintiff and the defendant, if it's a civil case, to a point where the plaintiff may take less money than they wanted to take, the defendant may pay more money than they wanted to pay, but in the end of the day, they've settled their case, and it's brought the litigation to an end.
So could it ever be that there's mediation and arbitration?
Sure.
Okay.
I, as a court-appointed arbitrator, have had people come in and say, can you help us try to mediate this? So I've walked through the mediation process. I've worked towards that. If it doesn't resolve it, then they'll have me hear the case and decide it as an arbitrator.
Good. Thank you, David. We hope that this has been helpful to you as we've addressed arbitration, mediation, class action suits. I'm not sure exactly what the end of the story is, but stay tuned because it's being watched in several states. Stay tuned to Law Matters. It matters to you.